Hey, hello, everyone. Welcome to today's webinar on negotiating with opposing counsel, where we will share some practical tools as well as psychological strategies that can achieve, hopefully, a legal resolution. A little bit about myself and why and how I've come to present this topic. I've been an academic for several years until 2022. Focusing on company law and sustainability. And in parallel, I've been a consultant solicitor to this day, but most importantly, have set up my mediation practice. So as you can appreciate, negotiations as well as how they might fit in with litigation are a very important part of what I do. And therefore, I thought this session would be very useful to those of you that are also in practice, but have a keen interest to know more about how you can couple the psychology of negotiations prior to any litigation going forward, and also some practical legal tips and advice as to how to structure your approach when it comes to opposing counsel. So what are today's learning objectives? And you'll see this on our slide. We want to make sure that you understand the basics of the legal and procedural context of negotiation, meaning how does that fit in within the civil justice system of England and Wales? So that means we'll be looking at relevant pre-action protocols as well as obligations under the civil procedure rules. Also, developing the know-how of strategically preparing for negotiation, not in abstract, by assessing leverage as well as client objectives, as well as procedural considerations. These three are all very, very important to be taken into account. Also, recognizing that we do have a series of techniques that can be employed to set the tone and establish authority early in the negotiation process, and often especially in the legal field, we're not taught how to do that. It's a matter of practice. So today we'll give you some tips on how to recognize these techniques, and hopefully you'll be able to use them in your negotiation practice. Very important also to understand how to structure and introduce offers and counteroffers, and that's why we're going to be looking at the effective use of Part 36 offers, as well as Kelderberg letters, and see how these two differ. And finally, learning how to identify psychological dynamics. And we're going to look at briefly at terms such as anchoring, reactive devaluation, because these are quite important because they impact legal bargaining. And as a very final point, we'll try and help you understand how negotiations are brought to a close and get a basic understanding of these behavioral and ethical tips for maintaining your professionalism, clarity, and client focus throughout up until the end.